a step-by-step guide to California Form FL-320, the responsive declaration to a request for order, covering how to respond to each request, attach supporting facts, and meet your filing and service deadline. What is Form FL-320? Form FL-320 is the California Judicial Council form titled Responsive Declaration to Request for Order. It is the standard way to respond when someone, usually the other parent or spouse in your case, has filed an FL-300 asking the court to make or change an order about child custody or visitation, parenting time, child support, spousal or partner support, attorney fees and costs, property control, restraining orders, or other requests available on FL-300. FL-320 mirrors the structure of FL-300 closely on purpose. For each type of order the other party requested, you get a corresponding place on FL-320 to say whether you agree, disagree, or ask for something different. Who files FL-320? The responding party. Whoever receives an FL-300 and wants to respond files the FL-320. This is often, but not always, the other spouse or parent in an ongoing case. Sometimes the requesting party themselves has to respond if the other side later files their own separate request. Filing an FL-320 does not concede anything about the underlying FL-300. It simply puts your position, and the facts supporting it, in front of the court before the hearing. If you have not yet read through the request you are responding to, our guide on how to fill out Form FL-300 walks through what each section of that form is asking for, which makes it easier to respond point by point. Forms filed alongside FL-320. Depending on what the FL-300 is asking for, your responsive declaration is often filed together with other documents. FL-320, FL-150, Income and Expense Declaration, MC-031, Additional Page, and Proof of Service. Our guide on how to fill out Form FL-150 covers that financial form section by section if support or fees are part of your case. Section-by-section walkthrough of FL-320. Here is the general process for completing FL-320, matched to the order the requests usually appear in on the FL-300 you received. Case information. At the top, fill in the county, case number, and the names of both parties exactly as they appear on the FL-300 and other case documents. Review each order requested on the FL-300. Go through the FL-300 you were served with, item by item. FL-320 is organized the same way, with matching sections for custody and visitation, child support, spousal or partner support, attorney fees, and other orders. Check consent or opposition for each request. For every request the other party made, FL-320 gives you a box to check indicating whether you consent to the order as requested, do not consent, and want the request denied, do not consent to the request as written, but want a different order instead. You can mix these responses across different sections. Consenting to a proposed holiday visitation schedule while opposing a proposed change in your custodial time, for example, is common. Address every request listed on the FL-300, not just the ones you disagree with. Leaving a section blank can be read as not having a position, which is not the same as consenting or opposing. Provide supporting facts. Wherever you oppose a request or want the court to understand the reasoning behind your position, use the declaration section of FL-320 to explain the relevant facts. If you need more room, attach a declaration on Form MC-031 and reference it on the main form. Keep your statements factual and specific. Judges reviewing an FL-320 are generally looking for concrete facts about the children, finances, or circumstances at issue, not general arguments. Attach a current FL-150 if support is at issue. If the FL-300 requests child support, spousal support, or attorney fees, attach a current, fully completed FL-150 income and expense declaration. The court needs current financial information from both sides to evaluate any support or fee request, and an incomplete or outdated FL-150 can slow down your hearing. Filing and serving your response on time. Once your FL-320 and any attachments are complete, you're required to file the original with the court clerk, serve a copy on the other party or their attorney if they are represented, file a proof of service showing when and how the other party was served. All of this needs to happen before your hearing, within the deadline set out in the paperwork you received with the FL-300. Because the exact number of days can vary based on your case and how service is completed, confirm your specific filing and service deadline with your County Superior Court Self-Help Center as soon as you receive the FL-300, rather than estimating it yourself. Common mistakes to avoid. Missing the filing and service deadline, which can limit what the court considers at the hearing. Not attaching a current FL-150 when child support, spousal support, or attorney fees are requested. Leaving one or more requests unaddressed instead of checking consent or opposition for each one. Writing a general objection instead of specific factual supporting statements. Serving the other party late or failing to file the proof of service afterward. Using outdated financial figures on the attached FL-150. What happens if you don't respond? Filing an FL-320 is not mandatory, but skipping it has real consequences. If you do not respond, the judge at the hearing generally has only the requesting party's FL-300 and supporting declarations to work from. That makes it harder for the court to hear your side of custody, support, or fee questions before deciding, and the resulting order may look closer to what the other party originally asked for. Even a brief FL-320 addressing the main points filed and served on time is generally better than no response at all. Filing fee and fee waiver. Responding to a request for order can involve a filing fee, generally in the same $435 to $450 range, charged for other family law filings, though fees are set locally and vary by county and by the type of request. If you cannot afford the fee, you can ask the court to waive it by filing Form FW001, Request to Waive Court Fees. Pro tip: confirm the current fee for responding to an FL-300 and your county's specific filing and service deadlines with your Superior Court Self-Help Center. These details can vary by county and can change over time. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your FL-320 for you. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.